Hello and welcome back to Business Matters at the Hindu with me, K. Bharat Kumar. Moonlighting has been a hot topic up for debate and discussion in recent months. What is moonlighting? Moonlighting is when employees work for entities other than their employers for extra remuneration, most probably outside of office hours. What has triggered this debate now? Moonlighting, as the name suggests, is work done after nightfall or by the light of the moon in the current context after normal working hours. A dictionary meaning also tells us that before the current context kicked in, moonlighters were those who committed agrarian outrages in Ireland. Moonlighting is not something new. If you look at stories of rags to riches, of billionaires who had very modest beginnings, the fact that they worked 2 or 3 jobs at the same time is not uncommon. Or if you want more normal examples that you would have seen in your daily lives, teachers, school teachers who take tuitions is another example of moonlighting, but that's an accepted norm in the education industry. So if moonlighting is not something new, why has it garnered attention now, especially from employers in the software industry? It's likely during the pandemic, which saw a lot of work from home by employees, there's no question of getting ready for office and then commuting to office. You generally tended to save about 2 to 3 hours because of this. So when you had more time at your disposal, it was easy for jobs that require only the use of a computer and access to the internet. It was easy for such professionals to do extra projects, take on extra projects and earn a bit of money on the side. In July this year, Kotak Securities said that in a survey that it had conducted, 60% of the 400 professionals surveyed said that they themselves had or knew someone who had engaged in moonlighting. In August, Wipro chairman Rishad Premji said that there's a lot of chatter in the industry about moonlighting, but in his opinion, this was nothing but cheating, plain and simple. Interestingly, moonlighting by employees has evoked a wide variety of reactions from companies. Wipro sacked 300 of its employees when it found out that they were working on the side with rival firms because it believed that had led to a conflict of interest. Infosys sent off a stern email last month saying this was not ethical and warned employees that if they were found moonlighting, it could lead to termination. DXC Technologies, another software services firm, said that moonlighting by employees was certainly a challenge for employers, but that would not prevent it from going ahead with its work from home policy, which had worked well for the company and its employees. Swiggy went against the grain and announced a moonlighting policy that allows employees to pursue their passions for economic interests alongside their full-time employment. While we were trying to gain a better understanding of the subject, moonlighting, we spoke to a variety of people, all employee profiles, across industry and across job profiles. This evoked extreme reactions. Some said that it was unethical on the part of the employee to go ahead and indulge in moonlighting, even if the agreement between employer and employee did not specifically prohibit moonlighting. There are others who said, what does it matter what I do with my own hours beyond office hours? The employer should not have any say in how I spend my extra time. If we keep all of that aside and look at what the law has to say, it's interesting. So we spoke to Mr. S. Ravindran, senior advocate who specializes in labor laws, and sought his views. He says that moonlighting has not been defined by any of the statutes in India. And he says, as far as his observation goes, no constitutional court has ever rendered a decision on the subject yet. He says there are 3 enactments which deal with double employment. The first is Section 60 of the Factories Act. This deals with restriction on double employment, stating, no adult worker shall be required or allowed to work in any factory on any day on which he has already been working in any other factory, save in such circumstances as may be prescribed. However, he says, this enactment is applicable only to employees working in factories. The second he refers to are state enactments which deal with employment of persons working in offices, banks, shops and the like. For example, in Tamil Nadu, it is called the Tamil Nadu Shops and Establishments Act of 1947. He says there is no provision that deals with dual employment. However, certain other states deal with dual employment, like Section 65 of Bombay Shops and Establishment Act, which restricts double employment after obtaining leave from the employer. The third, he says, is titled Industrial Employment Standing Orders Act of 1946. This prescribes conditions of service applicable to employees in factories as well as establishments such as shops, banks, offices and the like. Clause 8 of Schedule 1B of Central Rules prohibits workmen from taking up any employment in addition to his job and which adversely affects the interests of the employer. Moonlighting as a practice, he says, may be frowned upon by employers if they discover that their employees are working for some other company, but it is still subject to the laws of the land. The Supreme Court in the case of Glaxo Laboratories India Limited versus Labour Court Meerut and others held that the employer has hardly any extraterritorial jurisdiction. He is not the custodian of general law and order situation, nor the guru or mentor of his workmen for their well-regulated cultural advancement. If the power to regulate the behavior of the workmen outside duty hours and at any place wherever they may be was conferred upon the employer, contract of service may be reduced to contract of slavery. Of course, this particular case was not specific to moonlighting, but the observation gives us an idea as to how courts may view such cases. In other words, Mr. Ravindran says that the employee is at complete liberty to arrange his affairs as he or she pleases beyond the working hours fixed by the employer. In a situation that completely prohibits moonlighting by an employee, either under contract or under a statute, what would be the appropriate punitive action that an employer can take? Is termination of service the only option left to the employer? Or a lesser punishment such as a warning or an imposition of a fine be more proportionate? Mr. Ravindran feels that unless the employer can prove that the employee acted against the interests of the company when he or she was moonlighting, the courts may not uphold termination of service as appropriate punishment. Mr. Ravindran, of course, says we still have to wait for precedents in this regard. Mr. Ravindran goes on to explain his point in this regard. He says the courts of law in India dealing with employment are writ courts and labour courts. These courts exercise jurisdiction based on equity or fairness. Therefore, the courts may lean in favour of the employee unless the contravention of the employee has led to serious prejudice and loss to the employer. We've looked at different opinions. We looked at the ethics of the question. We looked at a legal opinion. Here's another perspective that came from a person who spent about 23 years in the software services industry. The person is in middle management. The person says that if companies have a right to terminate service of an employee because the company deems it fit, saying that this role is no more required, or the direction that the company is taking has changed, then what does the employee do? He says it's only appropriate that the employee throughout his or her working career makes sure that whatever opportunity offers itself to shore up their savings or to make sure that they remain employable, because you never know when the axe will fall. So that's just another perspective, but that does not justify violating an agreement. As Minister of State for Electronics and IT and Skills Development and Entrepreneurship, Mr. Rajiv Chandrasekhar, says that moonlighting is an idea whose time seems to have come. He urges companies not to suppress the energy of employees who want to develop, demonstrate, or even monetize their skills. But he says an agreement is an agreement. This does not mean that employees sign an agreement and go ahead and violate these agreements. So that's not the done thing. And who knows, maybe we are on the cusp of change. Work from home is such an accepted norm right now. But just think of your elderly relatives who were working in offices in the 1970s and 80s. Your accountant uncles would not have brought home ledgers even if it were possible, because it is unthinkable, it is not the norm. As we wind down this discussion on moonlighting, it may be appropriate to quote a LinkedIn post by the author named Paul Estes, and I hope I'm getting a surname right. He says, every company needs to have a gig economy strategy. Not having one is like having no internet strategy in 1999 or no mobile strategy in 2010. That's all for now, folks. See you again in the next episode of Business Matters. Have a lovely week ahead.